The EKURHULENI Protection Network case. The state versus Imogen Mabokane Mashazi and 3 others. The case number is D141/2026. IPID issued instructions that Julius Mkhwananzi be subjected to a disciplinary process. But at the Madlanga Commission, responsibility for implementing those instructions was passed from one office to the other. Human Resources pointed to legal. Legal pointed to management or alleged procedural defects. Management pointed back at HR and relied on legal advice. Mkhwananzi, on the other hand, disputed the basis for the discipline altogether. The result was simple. Everyone had a reason why they were not the person responsible for making the disciplinary process happen. Yet other disciplinary processes moved forward. Instead of implementing the IPID instructions against Julius Dr. Mkhwananzi, the same institutional machinery was allegedly used against officials who challenged or threatened the arrangement. Chief Isaac Mapie was subjected to disciplinary proceedings over comparatively minor allegations. Before that, his authority was weakened when officials usurped his powers, changed the EMPD organogram, shifted control away from his office. Then there is Mr. Nhlanhla Nciza. Nciza was pushed, Nciza himself pushed the implementation of the IPID instructions against Julius. He was dismissed. He was later vindicated and reinstated when all of these had been suspended. Deputy Chief Rivers Peace also sought to implement the IPID instructions. He was then subjected to a disciplinary proceeding related to his retirement benefits, something like that. Colonel Tsepa, who communicated publicly on behalf of the department or on behalf of the city, was bullied and unlawfully transferred from her position. The allegation is that the network, this protection network, wanted control not only over the disciplinary process, but also over the public narrative. The central question is, why was Julius, Dr. Mkhwananzi, not disciplined? The larger question is, was the disciplinary system deliberately redirected against the officials who tried to enforce the IPID instructions while protecting the official who was supposed to face them? That is the institutional pattern now in the courts. And now the people who blamed each other for the failure to act face criminal charges, including corruption, fraud, defeating the ends of justice, or obstructing justice. Those charges remain allegations until their court case is complete. The disciplinary process they prevented has now become part of a criminal case against them. Crime is like a credit card. You buy now, you pay later. The benefits may be immediate. They got promotions, they got the salary increases, they got what were bonuses. Accused number 1, Dr. Imogen Mabokane Mashazi. She says she's a retired pensioner, explained the disputed addresses, said she moved between leased properties because of threats to her life, disclosed substantial assets, denied fraud and corruption, and she says this case is very shallow and narrow, not so fast. Offered her passport, relied on medical conditions and family responsibilities. Actually, Let's rewind. Let's go back to this thing of addresses. She openly explains every address. The Meyersdale address mention, she listed for 3 months. Then there's a Waterfall Estate mention, she listed for 7 months. The Bedford View property denies that she ever resided there. The Sunward Park, she said she sold it in 2000. In Mpumalanga residence, she denies owning that property. And then the Brakpan, she says that is her current address. She also explains why she was moving from one mansion to the other. It's because of the alleged threats on her life. Then the assets declared. Her affidavit contains substantial financial disclosures, including her pension, a 5 million rand investment, a resident valued at approximately 4 million rands, a BMW 760i. She says she owes the bank. She got a loan or debt on it. She says her husband owns a Bentley GTC, a Bentley Beta. I don't even know what kind of ish. I can't even pronounce these names. A Porsche Cayenne, an office block in Braamfontein. These disclosures explain while the prosecutor later argued she could afford a much higher bail amount. In other words, she told the court that she has rich people problems. This is rich people problems. We move on. To accused number 2, Advocate Kemi Behari. He's a senior lawyer, and he has a fixed residence, no previous convictions. He says he's got a heart stent, diabetes, hypertension. He can't stay incarcerated. He can't. He really cannot. Denied wrongdoing, said the detention would prejudice other legal and oversight proceedings that he is involved in. And he requested a bail of 5,000 rands. And the judge said no, slapped 50,000 rands on him. Then we have accused number 3, Linda Gxasheka. He has stayed in the Bedford View residence for a long time. She says she's diabetic. She's the primary caregiver for her children, including one of them that has a chronic lung condition. She says she is a suspended employee with no previous convictions, or she said her passport is held with the city, something like that. She requested a bail of 20,000, but the judge said no, 50,000, 50K. And then we have accused number 4, Julius Dr. Mkhwananzi. He gave a detailed family history, extensive police career, a master's degree. He says he's diabetic. He disclosed another pending Brockburn criminal case that is on Schedule 5. And his compliance with those bail conditions, denied any corruption. He says that this is all political. And he requested a $10,000 bail because he is already on a 30K bail from a previous one. But the judge said no, 50K. So for Julius, he's paid 50 plus 30. So that's 80,000 in bails so far. Julius told the courts that he's taking care of his mother. Did he tell the Madlanga Commission that his mother died? Please share my content in your profiles. And please follow me because I will be following this case. Because we do not know what the charge sheet has on each one of them. So I'm hoping that in the next court date, we're going to get a full charge sheet. And that will be 28 August 2026 at 8:30 a.m. at the Jameson Magistrate Court. The purpose of this appointment is for further investigation and possible transfer of the matter to High Court. See you on the next one.